Hello everyone, welcome back to the channel. My name is Varun Kaushal and I am a legal intern at LEXIS and Company. Today I am going to discuss a very vast topic, that is annulment of marriage under Hindu law. Annulment of marriage. As per legal terminology, the term annulment refers making a marriage null and void or voidable in case the marriage is void ab initio, which means the marriage is considered to be invalid from its inception. Then it shall be automatically null, even though the statement of nullity is required to be established. Annulment is a legal process for declaration of marriage null and void. It can only be stated null and void if there are certain legal requirements were not met at the time of the marriage, and then it is considered to have been never existed legally. Such process is known as annulment, which is very different from divorce. The clear distinction between annulment and divorce is that the annulment refers to the marriage which has never existed at all, whereas the divorce dissolves the marriage. There are some grounds for annulment. The grounds for a marriage annulment are varied to the different jurisdictions but are limited to fraud, bigamy, blood relationship, and mental incompetence, and includes the following situations as well. Number 1, any of the spouse was already married to someone at the time of the marriage. Number 2, any of the spouse was young to get married or marries without the consent of parents or court. And number 3, any of the spouse was under the influence of drugs or alcohol at the time of the marriage. Number 4, any of the spouse was mentally incompetent. Number 5, if the consent was obtained through fraud or force. Number 6, any of the spouse was physically incompetent to get married. Basically, he is unable to have sexual intercourse. Number 7, the spouse who is sentenced for a lifetime imprisonment. Void marriages, and how can it be annulled? As per Section 11 of Hindu Marriage Act 1955, which deals with void marriages, described as the marriage solemnized after the commencement of the act shall be null and void and become null and void by presenting a petition through any of the party on the basis of the above mentioned grounds. So what is the concept of bigamy? In case any of the spouse was still legally married to another person at the time of the marriage to the other spouse, then the marriage is considered to be void and no requirement for applying the annulment before the court is mandatory. In M.M. Malhotra vs. Union of India, the court held that husband married a woman during subsistence of his first marriage. Such marriage being null and void, his subsequent marriage to another woman would not be case of plural marriage. Who can seek annulment? Any party to the marriage can file an application for the annulment for declaration of the marriage as null and void. However, this is just a procedure to be brought on record before the court and is done as the precaution so that in future no question of void marriage can be called. Now I'm going to tell you about the annulment process. Basically, the process of annulment of marriage is not a common process. Therefore, a person applying for the annulment has to meet the residency requirement where he or she is staying. Thereafter, the person can file the petition where he was born. The marriage was solemnized or has been living together and has to stay for continuous 90 days period before filling the application. The procedure for the annulment is almost similar to the divorce proceedings and can be filed by any of the party. However, the divorce is considered to be the most complicated process as compared to the annulment. There are some effects of annulment marriage. Annulling a marriage deletes all things from the records as if it never took place before. The outcome of a marriage annulment is a decree that the marriage never existed. It nullifies the marriage, returning the parties to their status before existed before marriage. It's very usual misinterpretation that short marriages can be annulled, but the length of the marriage is not a measuring factor. Many times annulments occur even after very short marriages, so there is no need to distribute the property between the parties or to decide the custody of children produced by the marriage. In the case of a longer marriage that is annulled, the court will distribute the property of the parties. So what are the rights of children to property inheritance after annulment of marriage? The status of legitimacy that is declared by Section 16 is part of the incidence of birth. The children born in a void or voidable marriage should be legitimate. If they were declared legitimate, then they cannot be discriminated against and they will be on a par with other legitimate children and be entitled to all the rights in the property of their parents, both self-acquired and ancestral. The deemed status of legitimacy entitles such children to inherit and demand partition of only the properties of their parents and includes any other properties. In the case of joint family property, such children will be entitled only to a share in their parents' property, but they cannot claim it on their own right. Logically, on the partition of an ancestral property, the property falling in the share of the parents of such children is regarded as their self-acquired and absolute property. Maintenance. Another important question that often arises is whether the wife whose marriage is void under Section 11 of the Act can claim maintenance from her husband of that void marriage. The Supreme Court has held that where a marriage is void, wife cannot claim maintenance under Section 488 CRPC, Section 125 under the Act of 1973, However, it is a generally accepted rule that even in such cases, the wife is entitled to maintenance under Section 18 of the Hindu Adoptions and Maintenance Act 1956, and also under Section 24 of the Hindu Marriage Act 1955. In conclusion, I like to say that there are two ways to legally end a marriage. Number A, annulment, and B, divorce. It can be initiated by either the husband or the wife in the marriage. Marriage which is void ab initio does not alter or affect the status of the parties, nor does it create between them any rights and obligations which must normally arise from a valid marriage, except such rights as are expressly recognized by the Act. Avoidable marriage remains valid and binding and continues to subsist for all purposes unless a decree is passed by the court annulling the same on any of the grounds mentioned in Section 12. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comments section, and don't forget to like, share and subscribe the channel. Let's click.